This next lecture is on insanity and competency, and this is an area that's really fascinating and it's relevant to just about everyday life because we see headlines regarding insanity and competency all the time. Like Jared Lee Loughner, the gentleman that shot the congresswoman in Arizona, he was recently found to be incompetent to stand trial. What exactly does that mean? Oftentimes students have questions about the insanity defense, or not guilty by reason of insanity. What does that mean? And I'm glad you're not in the classroom here with me today, because this is an area that really elicits a lot of debate in the classroom, and students feel very passionate about some of these issues, and I always have arguments in class. So I'm kind of glad you're not here, because I don't like to deal with that all the time. Now this picture right here is a picture of, any guesses? The crime scene when President Reagan was shot. A number of other individuals were shot, and obviously President Reagan survived this assassination attempt by a young man by the name of John Hinckley. This is a great example, and we'll talk about this case throughout the lecture. Okay, now if we look at the history of the insanity defense, we can look at writings from decades ago, centuries ago, and they all kind of sound similar. It's a little confusing, and we'll go through the evolution and de-evolution of the insanity defense and look at a number of different ways of conceptualizing insanity. Now, I want to make note that insanity here is a legal concept, not a psychological concept. So here, when we talk about insanity, this is from a legal perspective, not a psychological perspective. All right, now this is a legal treaty from 1581, and it says, if a madman or a natural fool or a lunatic in the time of his lunacy do kill a man, this is no felonious act, for they cannot be said to have any understanding will. I like this definition, and this was written in 1581. Now, I'm probably a little more sensitive to mental illness than the average Joe. You know, that's kind of my background area. But I think that if somebody commits a crime as a result of their mental illness and they can't control themselves, maybe we shouldn't punish them the same as someone that can. I think there should be a compromise. If a defendant is mentally incapable of controlling their behavior or conduct, I don't think that they should have the same punishment as someone that is capable of controlling their behavior. But what does that mean? Does that mean if I have a drinking problem and I can't control my drinking, that I'm able to go out and drive drunk? No, not even close. Let's talk about this a little more and review some relevant concepts. All right, the first thing that I want to talk about is mens rea. And what this literally means, is a Latin term, and it translates to guilty mind. And what we're talking about here is criminal intent. Did someone have the intent to commit the act? Intent we can define as a mental desire and a will to act in a particular way. So mens rea is very important in this discussion. Now, there's another concept here called diminished capacity or diminished responsibility. And in criminal law, this is a potential defense by which defendants argue that although they broke the law, they should not be held criminally liable for doing so, as their mental functions were diminished or impaired. So think about scenarios in which that might be applicable. Some of you might not think that this is ever applicable. Other of you might have some ideas about when diminished capacity or diminished responsibility would be relevant. Okay, not guilty by reason of insanity, or NGRI. This is actually a full defense to a crime. So if you plead not guilty by reason of insanity, it's equivalent to pleading not guilty. So that means that you are not guilty for the crime that you committed. Now, it might be because of mens rea or other factors, but it is a full defense for a crime. And that individual right here is Andrea Yates, who pled the insanity defense, not successfully. Now, Andrea Yates suffered from mental illness. She had a long documented history of depression. And she was very susceptible to postpartum depression or depression after pregnancy. And she was delusional. And she, let's see, the specifics of her delusions were about like Satan and the end of the world, and that she thought that she was protecting her children by killing them. And she actually did kill 5 of her children in less than an hour. She drowned them. And at her trial for capital murder, she pled the insanity defense based on this postpartum depression. This was in Texas, and that Texas jury rejected the argument and found her guilty. She received a life sentence for the murder. Now, students oftentimes have the idea that the insanity defense is used all the time, and it's a way to get out of your crimes. So you can fake mental illness and then be set free. That's completely ridiculous. Honestly, if you plead the insanity defense and you're found not guilty by reason of insanity, the amount of time that you could spend in a mental hospital could be significantly longer than the amount of time you would have received in a jail or prison for the specific crime. Now, the insanity defense is very rarely used. Research shows that it's used in less than 3% of all criminal cases in the United States. And of that 3%, roughly 25% of those individuals are actually found not guilty by reason of insanity. So we're looking at less than 1% of cases. Now, I want to review some historical individuals and conceptualizations of the insanity defense. The first famous legal test of insanity came in 1843 in the McNaughton case. And so this individual here is Daniel McNaughton. Prior to McNaughton, the British courts developed what they called the wild beast test. I love that name. So the wild beast test was, here, I'm going to read this quote here. If a defendant was so bereft of sanity that he understood the ramifications of his behavior no more than an infant, a brute, or a wild beast, he would not be held responsible for his crimes. So that was kind of what was in place. Now, this McNaughton case came along. Daniel McNaughton was a Scottish woodcutter, and he lived in London, and he was having a lot of psychological and personal and financial and social problems. Things were not going well for Mr. McNaughton. His life was in ruins, and he had a delusion. A delusion is a firmly held false belief that an individual has. Even if they're presented with information to the contrary, they would still hold that belief. It's rigidly held. And he felt as though the Prime Minister, Sir Robert Peel, was personally responsible for his financial ruin. So he held this belief, and he thought that the only way to save his life was to murder Sir Robert Peel, the Prime Minister. And he actually attempted to assassinate the Prime Minister. Unfortunately, he made a mistake, and he killed the Prime Minister's secretary, not the Prime Minister himself. And this was a very famous case, and it was very publicized. And after McNaughton's case, the McNaughton Rule to test for legal insanity was developed. And so here we have an evolution from the wild beast case, or the wild beast test, to the McNaughton Rule. And the McNaughton Rule states that a defendant should not be held responsible for his actions if he could not tell that his actions were wrong at the time he committed them. So we go from wild beast, which is if the defendant was so bereft of sanity, so as a result of his mental illness, basically, he didn't understand what he was doing. So his behavior was a result of mental illness. To McNaughton's rule, which really describes McNaughton's behavior. His behavior was a result of mental illness. Now, he knew what he was doing was wrong. And that's where the McNaughton test for insanity would kind of catch him. Because what the McNaughton test does is it looks at responsibility based on if the individual knew right from wrong. I like this cartoon. Why are you punishing me but not the cat? Well, the cat would fit the criteria for the insanity defense based on the McNaughton Rule. There's no point in punishing the cat. He doesn't know right from wrong. Okay, now, unfortunately, this McNaughton Rule isn't the greatest. It really focuses on cognitive ability to know right from wrong. It doesn't take into consideration the issue of control. Like, does your mental illness prevent you from controlling your behavior? Like, is your mental illness driving you to commit these acts even though you know they are wrong? So a lot of states in the US use the McNaughton Rule. And even though this was developed a long time ago, it's persisted. But some states supplement the McNaughton Rule with an irresistible impulse test, which adds that criteria. So not only do they know right from wrong, but whether they could control their impulses to commit the wrongdoing. And this was first adopted by the Alabama Supreme Court in 1887 in the case of Parsons Be State. So that case was, in the Parsons case, the court concluded that Parsons was subject to the duress of such mental disease that he had lost the power to choose between right and wrong, and that his free agency was at the time destroyed. And thus, the alleged crime was so connected with such mental disease in the relation of cause and effect as to have been the product of it solely. So, Parsons v. State, this really is kind of like, does the behavior result from the mental illness? Is it a product of the mental illness? And then we still have the McNaughton Rule, which is knowing right from wrong. All right, this led to another conceptualization of insanity with the Durham test. So Durham oftentimes is called specifically the product test. Now, Durham was convicted of rape, robbery, and assault with a deadly weapon. In Durham, the U.S. Court of Appeals for the District of Columbia ruled that a defendant could not be found criminally responsible if his unlawful act was the product of mental disease or mental defect. So with this product test, we remove right from wrong, and we only go to the behavior being the product of a mental illness.